We're unmuted. Welcome. Welcome, everyone. My name is Barb Van Hoy, and I am a policy analyst with the Community Development Division at the City of Colorado Springs. And it is my pleasure to welcome you tonight to Renter Rights 101, Health and Safety, also known as Habitability. I want to give a special thank you to Solid Rock Community Development Corporation and Church for hosting this event tonight. We are also doing our first try at a hybrid event with folks in person and online with Zoom, so please bear with us. Those of you who are joining us on Zoom, please be sure to keep your sound muted, and you can keep your video off, and then there will be opportunities to ask questions, and you'll be able to ask those questions using the chat function. And then if you have any other feedback or anything's not working, we have the fabulous Deb Hamilton, who's going to be making sure that everyone who is joining us remotely feels connected as much as possible. So these events, the Renter Rights Workshops, are produced in partnership with Colorado Legal Services, the Pikes Peak Library District, the Justice Center, and Colorado Housing Connects. We will hear from each of these organizations tonight about legal and housing resources available to folks in our community. And that'll be followed by some in-depth review of the rights and responsibilities of renters and landlords for health and safety living conditions. Our main speakers will talk about what constitutes a breach of warranty of habitability and explain what that means. For unsafe living conditions, who is required to fix what, how to work with your landlord if you're having problems, or your tenant, and also how to, where to get help if you need it. So the division, the Community Development Division for the City of Colorado Springs, manages the annual grants through HUD, the U.S. Department of Housing and Urban Development. These grants help the city fund partnerships in our community to increase the supply of affordable housing, to improve neighborhood facilities like community centers and bus stops. We provide, use that funding to provide services and quality of life improvements. We promote neighborhood economic development and work to reduce homelessness. These workshops in particular help us to advance fair housing and to prevent unjust evictions and keep people housed. So this workshop is part of our year-long series. I meant to have it right in front of me. We have two more workshops this year after this one, and you can find those on our website at coloradosprings.gov/community development. And there is also a renter rights packet. Thank you to Clinton Albert with Colorado Legal Services. Thank you. There's a renter rights packet that's online. You can download in both English and Spanish with a lot more detailed information. We will also be making the slides available for tonight's presentation to you by email. So there's an option for registering at the Justice Center's website. If you register there, even afterwards, we'll get your email address and we'll send you the slides. We'll also be providing those in the Community Development Division's newsletter that goes out about once a week, and you can subscribe to that on our website as well. So the other workshops coming up around renter rights this year, August 9th, is going to be focused on know your lease, how to understand what's in your lease, make sure that you don't get surprised at the wrong time. And then we'll do a sort of reprise of the overall Renter Rights 101 on November 15th. All right, so now I'm going to introduce some of our partner representatives from partner organizations who are going to talk about the resources that they provide. And first, I'm going to welcome Deborah Hamilton, who is the law librarian with Pikes Peak Library District. Please join me in welcoming Deb.
Hi, everyone. My name is Deb Hamilton. I work for Pikes Peak Library District. I'm going to just pull up really quick our legal resources website that we have at the library to show you a few things that are available to you. So if you go to the library's main website, which is just ppld.org, you can go ahead and click on research. And then in the middle here, you'll find law and click there. And here's where you can connect with a lot of different laws online, as well as different information about all the different legal service providers that we have in town. So once this page loads, I'll show you a few things. We also, though, have a physical collection at our downtown location, which is the Penrose Library at 20 North Cascade. So you can also go there in person to use our books or to also get onto the computer. And so I apologize, it's being a little slow. There we go. Okay. And so just a few things here really quickly. I don't want to take up too much of your time, but we have some databases that have different types of legal forms and books that explain the law available here. There's information about legal aid here. You can also find information about any upcoming legal programs there. If you scroll down, it's still loading, but there's my contact information. So if you have any questions later on, feel free to reach out and I can either answer them or connect you with someone who can. You'll learn about the Justice Center here in a minute. Here's information about their free legal clinic program and a couple other services they have. You can also find more information about Colorado legal services here. If you need to look up Colorado state laws, those are here in the revised statutes. And then there's also the judicial branch website, which has a lot of the different court forms for different types of landlord-tenant actions. And then lastly, there's information about the law clinic we do once a month at the Fountain Public Library. That's all I just wanted to quickly show you, but again, please feel free to reach out later if you have any follow-up questions. And for folks here in person, I do have my card there. So please feel free to take one of those.
Thank you. All right, I am going to pull up the Justice Center's website as we're bringing up Laura McKernan, who is the Executive Director of the Justice Center, which I think will come right up. Oh, it's thank you, there it is. All right, welcome, Laura.
Perfect. Hi, thank you everyone for coming and being here online or in person. My name is Laura McKernan. I am the Executive Director of the Justice Center. So the Justice Center is a nonprofit that has a mission of providing legal assistance and access to justice to those who cannot afford it. And we do that in various different ways that you can benefit from. So if you go on our website, which is justicecentercos.org, you can find the first resource that says need a lawyer. We have a program called Call a Lawyer. And in that one, you literally call the number that's displayed on the screen right now, 719-473-6212. That happens every Wednesday, every single one, from 7 to 8:30 o'clock at night. You will get attorneys who are licensed to practice law in Colorado who will answer your questions. And this can be about housing or about any other subject of the law that you think a qualified attorney could give you a better answer. So that's our first program for you. The second one is called Ask a Lawyer. If you have a question that perhaps you called into our line and our line was full, that happens sometimes, or you can't make it because you have a scheduling conflict or something of that nature, well, you can come here, you put your name, you put your email, you can guesstimate, if you don't know exactly what it is, the area of law the question you have is in regards to. So landlord tenant could be it, or it could be other, or it could be something else. Once you type that in, you give us a brief explanation of your question. So tell us what's happening. What do you need an answer with? So one of the common questions we get is, what type of lawyer do I need? Some people don't know what type of lawyer they need. So that's literally one of the questions we get. Another question we get is, what are the names of the courts that we have in Colorado Springs? So that can definitely be a question, or it could be something more complex. So you just type in your question and we'll get to you within 7 business days. The other program we have is called Find a Lawyer. And in that one, you actually can go in and get a free or reduced cost attorney provided to you. And that happens if you come from a household income below 200% of the federal poverty line. That would be a free representation, a pro bono publico program, or 275, a household income below 275 of the federal poverty line. And in that case, it would be a modest means or a reduced cost representation that you would get. How do you go about applying? Well, you click this button that says apply. If you need an application in Spanish, there's also an application in Spanish, solicitud en español, and you can apply through our website. We will get our amazing program director to answer your questions on that as well whenever you apply. The next thing we have is we have a bunch of educational tools for you. There's one that's called forms. In there, you will find sample forms for mutual rescission of a lease and for warrant habitability. So a demand letter to have a warranty of habitability. So we have those 2 forms that you can download and fill out to your proper specifications. We also have a toolkit for eviction prevention. In that toolkit, we have it available in English, in Spanish, and we also have it in Korean. That's the 3rd most spoken language in Colorado Springs. So you have it there in case that's your language of choice. And then we also have videos. And in these videos, we have a section called videos of landlord tenant. And here you'll find different ideas, different definitions of what you can use in a very condensed video format that you can definitely watch. Even if you have questions about that, you can do it through Ask a Lawyer. Hey, I saw in the video this and that about disability. Can you explain more? Of course we can. That's what we're here for. So we have one on reasonable accommodations. We have one on evictions during COVID, which are still happening, sadly. And we have one on assistance animals in housing. See, so if you have an assistance animal, service animal, therapy animal, that's what we're talking about here. We have one of crucial conversations with your landlord. What conversations should you have with your landlord? And then we have security deposits, which is a question that we get a lot. How can I get my security deposit back? I gave it and they're not giving it to me back. And I think I left it in perfect condition. Little secret, take pictures when you move in. That's our little secret. That's the best thing you can do. And then we have best practices for landlord-tenant communication, mutual rescission of a lease. Those are the videos we have there for you. If you need information on those topics, you can definitely get them there. So the Justice Center also has something on our website, which our marvelous Barb talked about, which is Renters' Rights RSVP, in case you want to sign up for our upcoming events. So people may sign up for today's event. Some of you did online, but you can also sign up for our August 9th event, Know Your Lease, and for our November 15th event, Renters' Rights 101. That's a bit about the Justice Center. We hope that you can find help when you most need it, and we are happy to be of assistance. Thank you very much.
All right, and next we have Katrina Brown, who is a housing counselor with Brothers Redevelopment and Colorado Housing Connects. Come on up, Katrina. What was there? Nope. Yes, that's it. Yeah. That is the one that we will take for a couple minutes for that to all come up.
Okay. Let's see here. Is it just not loading across or?
Just took a couple of minutes.
There we go. Okay, there we go. All right. Hello, everybody. My name is Katrina Brown, and I am with Brothers Redevelopment, and we run a line called Colorado Housing Connects. Basically, Colorado Housing Connects is your one-stop shop for housing questions, for people who want to become first-time homebuyers, for renters, for homeowners, for landlords. So on our line, you can call in if you have any sort of renter's question you think you may be being discriminated against. We will walk you through what the issues are. If you're a tenant, we will walk you through how to file a complaint with the Division of Housing. If you need help with rent, if you need help with mortgage, we will walk you through how to receive renters assistance, mortgage assistance. If you're looking for affordable housing, or just have an issue with your landlord is coming in your house when you're not home. I have one lady who was like, I wake up every day and my landlord is in my bathroom. That's weird, first of all. And, and you probably should call the police, but we did discuss what her rights were and go through her lease and find out if that was legal and talk to her about how to navigate that situation. And like I said, if you have any discrimination issues, we go through discrimination issues with you and show you how to file a complaint. If you are a homeowner or wanting to become a homeowner, we work with CHAFA and teach a first-time homebuyers class to help get financing for first-time homebuyers. We help first-time homebuyers navigate whether they are ready to buy a home. We do budget classes as well. And we do one-on-one budget classes, and we do budget classes with different agencies for group workshops, helping people wanting to become first-time homebuyers. If you have any concerns about buying a home, or you've already bought the home and now you have the concerns, we help with navigating those things, how to do property upkeep, how to change the what is that thing called? Filter on your furnace. See, I never change mine because I don't know what it is. That's somebody else's job at my house. So we do those kinds of things. And then we also help landlords navigate through things with renters. When those people call and say, when do I get my security deposit back? We have landlords that call and go, they left the apartment a hot mess. And do I have to give their security deposit back? So we navigate through things like that. Also, on our hotline, we try to, our biggest thing that we're helping with now is affordable housing. So we try really hard to navigate people through getting affordable housing. And as we all know, here in Colorado Springs, well, here in Colorado, period, that is a hard task. So one of the things that I spend my day doing is trying to find affordable housing for people, or sending them things that may be available to them. So those are some of the things we do at Colorado Housing Connects on the hotline. Now at Brothers, we also have a part of our company that does home modification and repair, and we help disabled people and we help seniors age in place. So if you're in your home and your parent is in their home and they want to stay in the home, we will come in and help put grab bars in. We will help put roofs on if a roof needs to go on. We'll help do ramps and things like that so that they can age where they are, rather than selling their home or having to move, because it's hard. And if you have a place, stay in it. So we do things like that. And that part of our company also does a thing called Paint-a-thon, where we will take a block of houses in a neighborhood and paint the block for free if they're single family dwellings and they're one story. So that's what we do at Brothers Redevelopment and Colorado Housing Connect. If you find yourself in need of any housing question, please give us a call at 1-844-926-6632. Thank you.
Thanks to all of our partners so much for doing that work, for providing all that help. And now I'll see if I can talk and pull up a presentation at the same time. Maybe I should just do one at a time. I am really grateful that we have Mitch Hams. Did I say your last name right? Mitch Hammis, as one of our two main speakers tonight. He is the Neighborhood Services Manager for the City of Colorado Springs. He has been with the city for 6 years, but in code enforcement for 23 years. Mitch is going to talk about health and safety and habitability from the perspective of code enforcement, along with the enforcement process and more. Please join me in welcoming Mitch Hammis. Sorry, Mitch. Okay, but I need to open it up. Here we go. That's this one. And I think, whoops. I can't talk and open things at the same time. How's that? All right.
All right, thanks. I'm Mitch. I'm gonna check to make sure I'm on the screen. Yep. I'm the neighborhood services manager with the city. So what I do is I oversee city's code enforcement officers who respond to blight violations, junk cars, tall weeds, as well as housing concerns, because the city's code enforcement, the city code contains provisions about minimum housing standards. The other part of what I cover is homeless camp cleanup, graffiti removal, and some other random stuff. Tonight, we're going to talk about minimum housing standards. And what it's important before we start this off is to understand two things. One, the provisions in the city code are city code. So it only pertains to what properties are in the city, and it only pertains to the provisions contained in that code. We often get people who are confused with what's in the city code versus the warranty of habitability. The warranty of habitability are state statutes that also sometimes mimic, sometimes are different than city code, but they talk about housing standards and other things like that. The problem is that city code enforcement, neighborhood services, does not enforce the state codes. So it's important to understand that difference. And that's where our next speaker will be able to give you some more information about how to deal with the warranty of habitability. All right, so the first screen we're going to talk about, and I hope you can see it, some exciting stuff, quick overview of code enforcement, our philosophy, that kind of stuff. Even though we're an enforcement agency of the city, what we look to do is solve problems first and foremost. So we don't get a call, come out and see a violation like this one on the screen and start writing somebody a ticket. What we do is we try to find out who's responsible, what happened, why is it there, and how do we get it cleaned up? How do we solve the problem? The very last thing we want to do is write a ticket or get a warrant from the court to go clean something up, because that involves fines, fees, all kinds of unhappy stuff. If we can work with the property owner or the responsible party, then that is the ultimate best outcome. All right, we're going to talk about some of the other stuff as we go through this. People often ask me, what's a standard process? What can I expect if code enforcement comes out, if I get contacted? The very first thing is we always look for voluntary compliance. So if somebody's willing to talk to us and help solve the problem, we can always work out time. We can talk about resources that are available. Lots of times people will have junk in their front yards and they'll say, well, I'm willing to get rid of it. I just can't, I don't have money for the dump or to get it there. Well, neighborhood services, we can provide a dumpster. If you'll load it up, we'll pay for the dumpster and we'll haul the trash off and dispose of it. And so, but those conversations don't start until people start talking, until we make contact and that kind of stuff. A normal enforcement process starts with a complaint that we receive. We do an inspection. If we find a violation, then we issue a notice and order, which is just a kind of a strongly worded letter asking you to fix what it is. And then based on the outcome, we'll do a re-inspection. If the violation's been fixed, we close the case. If there's been some work, we might give an extension. If there's other things that we can do to help speed the process. It's important to understand this process because it's the same process we use when somebody calls in and says, my kitchen sink is leaking and my landlord isn't doing anything. We don't run out and immediately handcuff or do anything to the landlord. We come out, we have to do an inspection, verify that it's a violation, and then give them give the landlord or the responsible party an opportunity to correct that condition. If they don't correct the condition, then we can issue reinspection fees, which is about $100 every time we come out. If we do an abatement, which means the city goes to the court, gets a warrant, orders us to fix it, then we can we can do that charge for our services. We can put a lien on it if they don't pay. We can issue tickets or criminal charges to property owners. There's a lot of things that we can do. And the one part that I put out there in every presentation I give, because today you might be calling because your landlord hasn't fixed something, but 2 years from now, maybe you're in a house and we're coming out saying, hey, you have this car that's on blocks, or you have these weeds that aren't cut. The philosophy of code enforcement is always that fines and fees should never be a surprise. So if a code officer comes out and says, hey, you need to fix this, or we found that, they're not going to give you any fine or fee or ticket or anything like that, just right off the bat and unexpectedly. You need to either not do what you've promised to do, or not do anything, or not communicate. Then that really ties our hands. All right. When it comes to the housing code, or the minimum housing standards contained in the city ordinance, it basically covers 3 provisions. You can't rent or occupy or lease to somebody else any dwelling unit, or which is a house, an apartment, a duplex, a mobile home, anything like that, unless it has certain basic equipment and facilities, light, ventilation and heating, and then space, use, and location. Those are the 3 things. We're going to break that down into what are the basic life safety type provisions. Well, it has to be sanitary. So you can't have toilets that are plugged and not working. You can't have water dripping all over. And this one is usually a surprise to most people. They'll call and say, hey, my landlord hasn't fixed this or that. And we walk in and there's trash everywhere. There's rotted food. We went into one a couple of years ago where a lady had a cat, and rather than changing the litter box, she just put new litter over the stuff that was in there. When the litter box was overflowing, then the bathroom turned into the litter box. And there was about 8 inches of litter on the floor in the bathroom. And she was complaining that the sink wasn't working. And we said, no, we're not going to look at the sink until you get this bathroom cleaned up. And that's the tenant's responsibility. So the big thing that I always tell people and ask tenants is, if you're calling us to come out because something needs to be done, make sure you've done your part first. I've seen rotting bananas under the baseboards. I've seen refrigerators that aren't plugged in and they're full of rotted food. Probably the worst thing I ever saw was a bathtub. The toilet backed up. The tenant never called the landlord, so they started using the bathtub for urine and fecal depository, and it was almost full. And please don't ever do that. Please, please, please don't do that. That was terrible for me as an inspector to see that. Here in Colorado Springs, HVAC, heating, ventilation, air conditioning, the city code requires that the unit be able to be heated to at least 70 degrees Fahrenheit at a height of 3 feet above the floor in the center of the room. So if somebody says, hey, it's cold in here, we're not going to do our measurement right by the window, but we will look and see, is that window or door weather tight? And if it's not, that's a violation of the minimum housing standards. The heating only has to be done during the winter months, which is October to March. So April, May, it gets cold, the city code just says during winter months. Portable heaters are not permitted on a permanent basis. So your landlord cannot say, hey, the HVAC unit doesn't work, but here, I'm going to give you a plug-in heater for each room. They can do that temporarily while they're getting the main unit fixed, but that cannot be the permanent means of heating your units. Service interruptions. What that talks about is, like, if the landlord is going to repair the water main, they have to give you notice that they're going to repair the water main and that your water is going to be off for a certain period of time. Keeping in mind that it's usually not the landlord, it's a contractor doing that work. And so if the contractor expects the water to be out for 3 hours and it's now 3 hours and 20 minutes, well, there could have been something that comes up. But if they project or plan for the water to be out 3 hours and 3 days later, the water's still out, that's a problem. Under that same code section, landlords cannot turn off your utilities or disconnect your water if you haven't paid the rent. That's a violation of the city code. There's other options for them, but they have to leave it on. Now, if you don't pay the bill and Colorado Springs Utilities comes out and cuts off your utilities, that's not the landlord's problem. When the landlord is responsible for the utilities, they can't just turn it off on you. Smoke detectors are required in every main hallway, living room, and bedroom. Okay, lots of times we get calls from tenants who say, my smoke detector doesn't work. And we go out and we look at it and there's no battery. Who's most responsible for the battery of that smoke detector? From a code enforcement perspective, it's the tenant, because it's just a cost of, that's what everybody has to do. You replace the 9-volt battery and you put it up there. The tenant is the one with the most reasonable access to do that minor maintenance. The city code also covers interior and exterior maintenance. There can't be holes in the wall. There can't be, what am I trying to say? There can't be holes in the walls. There can't be gaps in the doors and the windows or in the between the foundation and the stucco or the siding. Things have to be in good condition. And then pest extermination. People often ask, who's responsible for pest extermination? If you're in a 1 or 2 unit building, meaning a single family home or a duplex, that's the tenant's responsibility. If there's more than 2 connected units, meaning like a 4-plex or an apartment complex, the city code says the landlord is responsible. However, when we get called, we always ask and we always investigate, because we had a situation a few years ago where the code enforcement officer went out, saw that it was a 4-unit complex. One of the units had bed bugs, and so immediately told the landlord, you got to fix that. The landlord got upset and called me and said, hey, that tenant's been there for 4 years, and this is the first I've heard about bed bugs. So I called the tenant and said, have you been there for 4 years? And she said, yes. And I said, have you had bed bugs for 4 years? She said, no. I said, how do you think you got them? She said, well, I bought a mattress off Craigslist and went and picked it up. I said, how long ago was that? 2 weeks ago. Guess what? The tenant is responsible for those bed bugs. That's, that's just the way we're going to play it. And then I called the landlord back and said, no, the tenant's responsible. However, you might want to make sure your tenant takes care of that, because if those bed bugs spread to the other units, then it's going to be really hard. And there's going to be a lot of details on that we have to work out. The tenant took care of the bed bugs and everybody was happy. Oftentimes people will ask how many people can be in an apartment or in a dwelling unit. And often it's because they say, my neighbor has 13 people living in a 2-bedroom apartment. So this is actually, I just cut it out of the city code. It shows every dwelling unit shall contain at least 125 square feet for 1 person, 200 square feet for 2 people, and up from there. It's based on the total habitable room area. So we're not calculating spaces of hallways or bathrooms. We're calculating living room, den, office, bedrooms, that kind of stuff. All right. And then it also talks about this, how many square feet each bedroom has to have, whether you can, the height of the windows for emergency egress, that kind of stuff. All right. One of the things that our city code contains is a definition of a family. And it says it's an individual, 2 or more persons related by blood, marriage, adoption, or similar legal relationship. This is problematic because there's parts of our city code that says you can only have 5 unrelated individuals living in a house. Well, we get calls on this all the time when it relates to short-term rentals and other stuff. How do you prove relationship status? And the simple answer is we can't. Because we can't look at you and say, yep, you both look the same. We can't say, show me your ID, because it's very possible for two people to be related, a husband and wife, but they have different last names because one didn't take the other. So what we look for in that situation is, what are the tangible problems? What is the real problem? It's not that there's 5 people or 8 people living in the house. It's the trash that's accumulating. It's the parking. It's the parties. It's smoking pot and the smell goes through the window or through the walls. It's those other issues. So what we do is when we come out, we try to find out what's the real problem, because relationship status is not the problem in most of these cases. All right. The majority of cases that get called into neighborhood services come from 4 different spaces. One is landlord-tenant disputes. The other one is evictions, health concerns, and neighbor disputes. So a landlord-tenant dispute is where the tenant says, hey, I reported this to the property owner or the property manager, and it hasn't been fixed. And that's pretty simple. We say, okay, great. Can we come out and inspect? We take a look, we find if there's a violation, and then we start that conversation. And it's not, we're on the tenant side or we're on the landlord side. We want to get that specific violating condition corrected. Evictions, people, I would say 80% of the housing case complaints that we receive are people who think, hey, I'm getting evicted, but if I make a complaint about minimum housing standards, it's going to stop the eviction, or it's going to help me in my eviction hearing. Here's the deal. It's not. Because in our perspective as city code enforcement, we're coming out, we're looking at what's the condition and trying to get it fixed. Lots of times we get calls, people will say, I need you to come out and inspect. There's no battery in my smoke alarm, and my bathroom sink leaks, and my eviction hearing is tomorrow. And my first question is, why are we waiting till the day before the eviction hearing? And because the battery in the smoke detector and the leaky sink is something that can easily be manipulated. I never tell people, I think you manipulated it, but it's easy access, easy to say that there's a violation. And again, we don't act on behalf of the landlord or the tenant. We're the neutral party that's just trying to get the situation fixed. People often call in with health concerns. They'll say, this is the number one thing, there's mold in my apartment. The unfortunate part of that situation is that our city code, which is the only code that neighborhood services can enforce, it does not contain any provisions for mold. So your house, your apartment could be covered mold from top to bottom. We can't do anything about the mold. Now, we can possibly look at what's causing the mold. Is there a leak in the sink? Is there a leak in the dishwasher? Can we find evidence of a leak? We can't go cutting walls apart to see, is there a broken pipe behind the wall? But we can take a look and see if there's anything obvious that's causing that. Okay. The 4th main option, or the 4th main source of complaints, are neighbor disputes. One neighbor doesn't like the other neighbor. They used to be friends, and then something happened, and now they're not friends. And now it's 13 people living in the house. I can smell pot coming through the window or the door, or one of 100 other conditions. In those situations, because we're enforcing minimum housing standards, we have to be able to legally enter the dwelling unit, which means somebody who has authority to grant access to that unit has to let us in. So you can't call and say, hey, my neighbor's a hoarder. You need to go in there and you need to fix the problem. Now, we do walk up to the door and we'll say, hey, we got a complaint that there's some unhealthy issues, or that there's some minimum housing standard conditions that we should look at. Will you let us in? The occupant typically says, who made the complaint? We say, you didn't, and we're not going to tell you who did. You can file a records request if you like, but that's really who made the complaint's not important. It's what are the conditions and can we help you solve them? And I think in my 23 years, I've only had about a dozen people who said, yeah, come on in. And then we went in, we found tons of violations, and guess who had to fix it? That person who let us in. And so people typically don't let us in unless they have somebody else who's going to be responsible for those violations. All right, and I think that's it for my presentation. If there's any questions, I'm available to answer questions. Thanks. Is there any in the chat? Okay. Oh, sure.
So I had a client that called about, he is the owner of the house, and he's a landlord. He got a complaint from the city that his tenants have cars on the private property that are not registered. And we want him to enforce the registration to the tenants. And he feels that that is none of his business, what those people are doing with their cars. And they're not on the street, and they're parked privately, and why should he have to enforce it and doesn't?
So that's a great set of facts. The property owner is always ultimately responsible for what occurs on the property. Okay, and that's from an enforcement perspective. But because our philosophy is we try to find out who is the most responsible, very rarely will we say, Mr. Property Owner or Mrs. Property Owner, you have to get your tenant to do this or that. We will take action against the tenant. Okay. With cars, if they are purely unregistered, meaning they don't have current registration, and that's the only condition, then code enforcement is going to say we are not taking action on that, because all that tag says is that you've paid the tax to drive that on the road. And it doesn't contribute to blight. It doesn't contribute to anything else. So now if the car has a smashed front end, no windshield, the side's bashed in, it's missing two doors, and it's unregistered, then yes, we're going to take it. But if it's typically just, hey, the car's there, it looks like they drove it home from work tonight, they're going to leave in the morning, and it has a 2020 sticker instead of a 2022 sticker, we are not going to take that.
I guess one of them is out of state registered and the other has nothing. One run and one run.
Now, if it doesn't run, then we can take a look at that. That's a little bit right. And just saying, hey, that car hasn't moved in 3 years, that's not a violation. But if it hasn't moved in 3 years and it's got, tumbleweeds underneath it, and and flat tires, and there's a bunch of trash or personal stuff stored inside, that's a different story.
Okay. So it doesn't matter that it is his property. He doesn't care.
And I would venture to say that at some point, there's a neighbor dispute there.
Okay.
Because nobody I've ever known in 23 years is driving down the street and goes, hey, that car doesn't have current stickers. It looks like it's perfect, but it doesn't have current stickers. I better call the city and have them take care of that. I've never had that happen. Yeah. Sure. All right. Yes.
So you had talked about sometimes when you get people who call about problems that are not in the code. Mold is an example, and I happen to know that Clinton is going to be talking about that. Do the city code folks who come out often, are you able to, are you empowered to connect people with resources to help them if it's not a city code issue?
So yes and no. We're not going to say, oh, here's 3 mold abatement people, you should call them, because that would be an endorsement, the city endorsing these vendors. We would say, you know what, you're having a problem. This might be a warranty of habitability issue. It's not a city code violation. You should call the Justice Center or Clinton or another agency, and we definitely have those that we send out. Did we have a, okay.
Does the landlord need to enforce teens/kids throwing rocks at units, leaving out trash, fighting with smaller children, causing
So everything that you talked about in that question, with the exception of trash, is a police matter. Okay, you need to call it in when it's happening. I'm not saying that the police will put on lights and sirens and be out there in 3 minutes because one kid threw a rock at another kid, but that's a police matter. That's a crime, assault or something else. I'm not a lawyer or a police officer, but if there's trash, then absolutely. That's something you can call neighborhood services and we will address that. Good. Yeah. Bedrooms. And that's a new code that just went into effect this year, that each bedroom has to have one. So, and neighborhood services is not inspecting every apartment in the city and every bedroom to make sure it has a smoke detector. But what we're doing is when we get called out and we go, that as we do our inspection, we take a look and say, oh, the bedrooms don't have it. And then we include that on our notice to the landlord that you need to get the smoke detector in there. The other thing that we have started doing in the last couple of months is because it's so common for smoke detectors to not have batteries. Our inspectors have 9-volt batteries. And so they'll say, hey, here's a battery, you install it. We provide the battery, we don't install it because we don't want to, God forbid, there's a fire that night. We don't want somebody to say, hey, the city installed the battery wrong and now, my dog or my kid died in the fire and it's the city's fault. We will provide the battery. You have to do the rest. All right. That's it. All right. Well, thank you very much. Thanks.
Yeah, great information. All right. All right, so now we know what city code enforcement is for and what they can help with. And I am now excited to introduce our next speaker, Clinton Albert. He is a housing attorney with Colorado Legal Services, where he served for, I used to have 3, now it's 4 years. And his caseload is made up solely of landlord tenant matters and covers a broad range of legal issues within that area. Clinton will talk now about state law, what state law addresses, including some of those things that are not covered by city code. Please join me in welcoming Clinton Albert. Yay. And let's see if I can open up. There it is. And, taking away my pen.
Thank you so much, Barb. Good evening, everybody. I'm Clinton Albert. I'm a housing attorney with Colorado Legal Services. And tonight we're going to be taking a focus on the warranty of habitability and what rights tenants have in regards to conditions issues that they may face in their residence. A few things to keep in mind as we start this evening, that this presentation is for informational purposes only. Housing issues require a thoughtful analysis of both the facts and the law that may apply to your case. So if you are a low-income citizen or senior citizen and are facing a housing issue, you may contact Colorado Legal Services at 719-471-0380, in person at 617 South Nevada Avenue, or online at www.coloradolegalservices.org. So jumping right into things here, what is the warranty of habitability? This is the promise that your residence is fit for human living. Now, Mitch was just talking about code enforcement. This comes from the legislature, so this is the state law that applies all over Colorado. There are a list of things that by law must be present in your residence. The first step in any kind of warranty of habitability issue is the notice that a tenant provides to the landlord. If there is an uninhabitable condition in the home, the tenant must provide a reasonably complete written notice or an electronic notice. An electronic notice, just to be clear here, a work order is not notice for the warranty of habitability purposes. You can certainly submit a work order and a warranty of habitability notice at the same time, but a work order, you run the risk of it not being construed as a reasonably complete written notice of the uninhabitable condition. So what makes up an electronic notice? It is notice by email or electronic portal or management communication system that is available to both a landlord and a tenant. If you send an electronic notice, you must send it to only the email address, phone number, or electronic portal that is specified by the landlord in the rental agreement. So as Barb had indicated earlier, in August of this year, we're going to be discussing kind of how to read your lease. But one thing right here is to pay attention as you're reviewing it is, where am I going to send any kind of electronic notice for issues related to the warranty of habitability? If your agreement indicates to send electronic notice to an email address, then sending it to a text message will not be electronic notice for the purposes of warranty of habitability. Your landlord may take action based upon that notice, but as far as kind of triggering the statutory protections that you'll have as a tenant, that wouldn't be sufficient notice. But what if you've got a lease that's a few years old and it does not have a provision that says, well, this is where you send your electronic notice? Well, then it's custom, it's habit. It's how have you communicated in the past? If your landlord has emailed you in the past, then that would be the method that you'd be able to provide an electronic notice. If there has been text messaging in the past, then that would be the method of communication that you'd be allowed to send an electronic notice to your landlord. Again, this is key, and that's you must retain sufficient proof of delivery of the electronic notice. That is important because, and we'll get to this in a little bit, your options as a tenant of what remedies you may have, terminating a lease, filing a small claims action, potentially withholding rent. Those are all going to be dependent upon timelines. So you want to make sure that you have proof of the delivery and the receipt so you can establish a timeline of either this was when action was taken or this is when action was not taken. So what are the conditions? What is this list of things that must be present or in some cases not be present when we're talking about the habitability of your residence? And I'm just going to check the chat here real quick to make sure there aren't any initial questions. All right. Well, sorry about that, folks. So conditions subject to the warranty of habitability. There has to be sufficient waterproofing and weather protection of your roof, walls, doors, and windows. Broken doors, those are all subject to the warranty of habitability. You've got to have plumbing and gas that is in good working order. It also has to be installed properly as well. Running water, reasonable amounts of hot water, proper fixtures, connections to sewage disposal systems. You've got to have functioning heating facilities that are in good working order and in compliance with the law. There has to be electrical lighting and wiring and equipment that is also in good working order and in compliance with the law. The common areas under control of the landlord must be kept reasonably clean. There is somewhat of an exception on this front, and that is that as far as using common areas as a basis to terminate your lease, the common area must be in such bad shape that essentially you can't go to or from your residence. Right? There must be an appropriate extermination in response to an infestation. And this is going to be an area where code enforcement may kind of vary a little bit from the warranty of habitability. And that's as we specifically get into bed bugs in residential premises. So as a tenant, you have to notify your landlord via written or electronic notice when you know or you reasonably suspect that your dwelling unit contains bed bugs. Now, landlords, when you get that notice, you've got to take some actions pretty quickly. Not only because the law says so, but in my opinion, it's best to maintain your property by getting rid of this infestation as quickly as possible. So landlords, within 96 hours of receiving a tenant's notice, you must provide the tenant with a 48-hour notice of a landlord or inspector or pest control agent's intent to enter the building, and you must obtain an inspection from a qualified inspector. You may also, as a landlord, if you receive this notice of bed bugs, you may also enter the dwelling unit or any contiguous unit to that dwelling for the purpose of inspecting the unit for bed bugs. If the inspection confirms that bed bugs are present in the unit, then as a landlord, you then have to go and inspect all contiguous dwelling units as promptly as is reasonably practical. Kind of the logic behind that is if you treat one unit in a multi-unit building without looking at the other units, then you're running the risk of just having that infestation just kind of spread after the initial source. Landlords, you are responsible for all costs associated with an inspection and treatment of bed bugs in the residence. So after an inspection, landlords are then, you have to provide your tenant with a written notice within 2 business days. And that notice must indicate whether or not the dwelling unit does in fact contain bed bugs. If the inspector that you've hired conducts the inspection and comes back and says, nope, no bed bugs, then the notice must inform the tenant that there are not bed bugs. And if their concerns remain, that they may contact the local health department. If an inspector does confirm the presence of bed bugs, then the landlord must provide that, the inspector must provide a report to the landlord within 24 hours. So once this inspection has occurred, within the next 5 business days, as the landlord, you've got to start taking remedial action to effectively treat the bed bug presence, okay, including retaining pest control services. It's my opinion that simply handing your tenant a can of Raid and saying, you know, have fun, that's not going to be sufficient for the warranty of habitability purposes, and you may expose yourself to liability if you take that route. While landlords are required to obtain the inspection and the treatment, the tenants then have to comply with reasonable measures to permit the inspection and treatment. If that may include things like moving the furniture to the center of the room, bagging or boxing up clothing or household wares. Those are all going to be costs that the tenant has to bear. If they have to buy kind of tubs to store maybe dishware or kitchen supplies in, those are going to be the tenant's responsibilities. And they do have to provide access to the landlord's agent or the inspector or the treatment folks to be able to come in and deal with this infestation. So again, tenants are responsible for preparing a residence for the inspection and treatment. As a tenant, if you know about the inspection and you unreasonably fail to comply with the inspection and treatment requirements, you then may be liable for the cost of any treatments for contiguous dwelling units if your non-compliance as a tenant allowed that infestation to spread to your neighbors in the building. Landlords, if you know or you reasonably suspect that a unit contains bed bugs, then you are not permitted to rent that unit. And if you have a tenant, if you receive a request from a tenant about whether the unit has contained bed bugs, you are required to inform that prospective tenant, that applicant, whether within the last 8 months the unit was inspected for bed bugs and found to be free of them, or the last date that such an inspection occurred. So what about liability as resulting from bed bugs? You know, what if the landlord doesn't take action versus the tenant? Landlords who fail to comply are responsible for a tenant's actual damages. Landlords may apply for injunctive relief against the tenant who refuses to provide reasonable access to the dwelling or fails to comply with reasonable requests for inspection or treatment. If a court does find that a tenant has unreasonably failed to comply, then that court may issue an injunctive relief to include granting access to the dwelling, the right to inspect and treat the dwelling, and requiring the tenant to pay to comply with the inspection and treatment, and or assessing the costs and damages of that non-compliance. So we're still on that list of items that must be present in your residence, as landlords are required to provide an adequate amount of outside receptacles for garbage. I'll be candid, I've not seen this type of issue come up, but if you think about it in a way of, let's say you've got a 20-unit complex and there is 1 trash can outside, that's not going to be an adequate amount. There need to be working floors, stairways, and railings. Locks on exterior doors, but they must be functioning and in working order. There also must be security devices on any windows that open. So if you've got a window that opens, make sure that the lock is functioning on it. If you have a window that's meant to be opened, but it does not, that may then fall in, that may be another issue because we don't have a functioning window. So similar to a window that is broken, a window that is meant to open that does not open may be rise to the level of an uninhabitable condition. There also must be compliance with all applicable building, housing, and health codes, which would materially interfere with your life, health, or safety. There must be functioning appliances maintained in good working order. But more specifically here, and we'll get to that in a little bit, we're really talking more about refrigerators, stoves, and ovens. Not so much if there's a dehumidifier or an air conditioning unit. those are just a little bit different. Those are not in the statutory definition of an appliance. Mold is another issue that the warranty of habitability addresses that Colorado Springs City Code does not. What is mold? It's microscopic organisms or fungi that can grow in damp conditions in the interior of a building, and a residence is uninhabitable due to mold when there is mold that is associated with dampness, or there is any other condition causing the residential premises to be damp, which, if that's not fixed, would materially interfere with the life, health, or safety of the tenant. But this doesn't include minor mold found on surfaces and mold that's found on surfaces that can accumulate moisture as part of their function. So if we're talking about mold in the shower, that may not rise to the level. But if we're talking about mold in a bedroom closet, we're talking about a different location in the home and maybe a different analysis at that point. So what about appliances? So refrigerators, range stoves, or ovens, which are included within the residence for the use of the tenant pursuant to the rental agreement or any other agreement between the landlord and the tenant. That's the statutory definition of an appliance for the purposes of the warranty of habitability. This applies only to the appliances specifically listed in a written agreement or otherwise actually provided by your landlord at the beginning of your tenancy. If you move into a place and there's a really fancy fridge breaks and you get a less fancy fridge, there's a legal presumption that the less fancy fridge is not in retaliation so long as it does substantially the same things as the fancy fridge. So if you think about maybe one that has the little touch screens on them versus one that doesn't, it's not retaliatory just because you lose your touchscreen fridge. There's also any condition that would materially interfere with your life, health, or safety as a tenant. This is a subjective standard that may be based upon your individual characteristics, and it significantly alters a landlord's response when we're dealing with notice requirements and landlord response requirements. So those are all of the conditions that are subject to the warranty of habitability. But when does a landlord actually breach the warranty of habitability? First, the residence has to be uninhabitable, one of those conditions that we just reviewed, or the premises is in a condition that materially interferes with the tenant's life, health, or safety. And this is the critical part. And the landlord has received reasonably complete written or electronic notice of the condition and failed to commence remedial action by employing reasonable efforts within the required times. If you've dealt with an uninhabitable condition in the past, but there was not a written or electronic notice, there's not a breach of the warranty of habitability, because as a tenant, you are required to provide that notice to the landlord. That notice is what puts the landlord on notice of, hey, there's an uninhabitable condition in my home. This affects the warranty of habitability. So what is not a breach of the warranty of habitability? Again, as a tenant, if you don't provide written or electronic notice, then there is not a breach of the warranty of habitability, even if you are dealing with a multitude of uninhabitable conditions. You've got to get that notice out first. If it's your actions or inactions that prevented a landlord from curing the uninhabitable condition, it's not a breach of the warranty of habitability. If the condition is the result of your action or inaction in another dwelling unit or another third party, and the landlord has taken reasonable necessary steps to fix it, but cannot do so due to conditions beyond the landlord's control. So if there's a third party that's kind of creating the issue, that may not be a breach of the warranty of habitability for your landlord in that circumstance. But let's say you provided that written notice. How long, or landlords, let's say you've received that written notice, what's the next step? When does that have to occur? There are three different timelines when thinking about warranty of habitability. The first is for a condition that materially interferes with your life, health, or safety. The second is a condition that is uninhabitable by statute, one of that lists. And the third is mold, because mold has a more detailed timeline that we'll get to. So if it's life, health, or safety, landlords have 24 hours to begin to commence remedial action or to provide a response. It's by statutory condition. Landlords have 96 hours to begin to commence remedial action. But this 96 hours only applies if in your notice, in the tenant's notice, they've included permission for the landlord or the landlord's authorized agent to enter the premises, to conduct those, to start those remedial actions to fix the issue. But what about mold? So this is going to have a lot of benchmarks in it, and that's at within 96 hours after receiving the notice. Landlords have to install a containment, stopping active sources of water to the mold, install a high efficiency particulate air filtration device to reduce exposure. And they also have to maintain that containment until the following things are completed. And that's establishing appropriate protections for workers and occupants, eliminating or limiting moisture sources and drying all materials, decontaminating and removing damaged materials as appropriate, evaluating whether the premises have been, whether the issue's been fixed, and then reassemble the premises to try to control the sources of moisture and to limit or prevent any future recurrences of the issue. So as if you've provided your landlord with a notice of the warranty of habitability, are you entitled to a response? And the answer is a resounding yes. As a landlord, you're required to respond to a tenant's reasonably complete notice within 24 hours of receiving the notice. The response must contain your intention for remedying the condition, an estimate of when you're going to start fixing the problem, and how long it's going to take to fix the problem. What about, is there ever a situation in which your landlord would be required to provide you with an alternate residence? And again, the answer is yes. If the residence is uninhabitable due to a condition that materially interferes with your life, health, or safety, and the tenant makes a request for an alternate residence, then a landlord shall provide a comparable dwelling unit selected by the landlord or a hotel room as selected by the landlord. These are at no expense or cost to the tenant, but the tenant is required to continue to pay rent as it becomes due under the lease. And as far as kind of moving costs into this alternate resident, that is not the landlord's responsibility, but that would be the tenant's responsibility. And again, this only applies to conditions that result in the material interference with your life, health, or safety. So what can a tenant do if the landlord breaches the warranty of habitability? Your home is uninhabitable. You've provided notice to your landlord and nothing has happened in response to that notice. So what options do you have? You can terminate the lease. You can obtain injunctive relief in county court or district court. You can defend against there are monetary options such as withholding rent, and you can defend against an eviction for non-payment of rent based upon the breach of the warranty of habitability. There are also options such as deducting the cost of repairs, which I'll discuss very briefly. So let's talk about terminating a lease based upon the warranty of habitability. At the beginning, when I was describing the electronic notice section, this is just one instance where it's really important to have that proof of when this was sent and when it was received. Because 10 to 30 days after providing notice to your landlord and 5 business days after your landlord has received notice of the breach, as a tenant, you may terminate the lease if there has not been any kind of action taken. If the uninhabitable condition can be repaired or damages paid to the tenant or otherwise within that 5 business day period, then the tenant cannot terminate the lease. Tenants can also apply for injunctive relief if there is a breach of the warranty of habitability, and this can be done in either county court or district court. Injunctive relief is meant to have the landlord act in a certain way or stop acting in a certain way. If the court orders injunctive relief, it shall determine what the tenant's actual damages are at the time the court issues its order. So that would be if a tenant, for example, if they had to stay at a hotel room and the landlord did not pay for that, those would be potential actual damages. If say space heaters had to be purchased to make up for the heat that goes out in the winter, those are all potential damages that the tenant has suffered. But landlords, they may not be subject to this injunctive order if they pay those actual damages within 2 days, and the uninhabitable condition is not an unrepaired condition that materially interfered with the life, health, or safety of a tenant. If the tenant vacates the lease if the tenant vacates the leased premises, then the landlord cannot re-rent the premises until the repairs have been completed. There's a monetary option if we're dealing with a breach that involves withholding rent. You might need to pay the amount of rent you're withholding into the court registry to defend yourself against an eviction for non-payment. If you choose to withhold your rent, act as though you have not. Set that money aside if you can to the best of your ability, and don't spend it, because, and we'll get to this in just a second, and that's going to be the bond that may be required to use that as a defense. One potential pitfall of withholding rent is that if there is a problem with the notice, or there was not notice provided to the landlord prior to withholding rent, then there's not a breach of the warranty of habitability, and the withholding rent will be done without a defense, without any kind of legal defense. You'd be able to cure the non-payment if an eviction is filed, but that would be more costly because likely there will be late fees that have been incurred at that point. So again, I would highly recommend seeking some kind of legal counsel before taking the step of withholding rent to make sure that you're not setting yourself up for a worse outcome down the line. And remember, you can bring a claim for a breach of the warranty of habitability outside an eviction action. You do not have to kind of wait for your landlord to take you to court to be able to assert this. You, in fact, can take your landlord to court over the warranty of habitability as well. So what about the warranty of habitability as a defense against a non-payment eviction? So if an eviction action is based upon non-payment, the breach of the warranty of habitability is a defense if the tenant has provided that notice to the landlord and the tenant pays into the court registry all or part of the rent accrued after consideration of, essentially, this is why you don't, if you're withholding the rent money, you have to keep it set aside because you may be ordered to pay that money into the court registry in order to use the defense that there was a breach of the warranty of habitability. If a tenant is found to be indigent by the court, though, then they will not have to pay, they will not be required to pay any amounts into the court registry to be able to use the warranty of habitability as a defense against eviction. What does it mean there is a specific formula for indigency for the purposes of warranty of habitability. It's right here. I'm going to kind of move past this slide. That way we can still have time for questions at the end. But again, if this is something that would be determined really at a court, at a hearing on whether or not there is indigency that would waive a tenant's requirement to pay into the court registry to be able to use the warranty of habitability as a defense against an eviction for non-payment. Tenants are also able to deduct the cost of repairs. This is an incredibly specific process. It does not apply to everyone, and there are a lot of timelines and kind of benchmarks to go through. Even in this you can't deduct for certain issues. So even in this more specific breakdown, I really don't think that this can be really broken down and explained very well. If you're considering deducting the cost, make sure that you seek legal advice before doing this, because again, similar to withholding rent, if you wrongfully deduct rent, then your landlord may be able to get a money judgment in that amount. You'll also likely be evicted for non-payment. And if it's a bad faith deduction, then it's an automatic eviction and 2 times the amount that was withheld. So there are some real potential dangers if this is not done correctly. And it is a very specific process of obtaining appraisals and kind of having battling appraisals if your landlord doesn't like the one that you've obtained for getting the repairs done to the residence. What about exceptions? Does the warranty of habitability, are there any exceptions to this? And there are. If there is a written agreement that is separate from the lease agreement, so it can't just be paragraph 18 in your lease, but a separate agreement, lease addendum, whatever it is, that is signed by both parties, the landlord and the tenant, and is supported by adequate consideration. Also, the tenant must have the skills to perform the work. So if somebody, say, is a is an electrician by trade. They may make an agreement to be able to manage the electrical components or electrical wiring of the home in exchange for some kind of rent reduction. Also, the premises must be a single family residence and a single family residence for which a landlord does not receive a governmental subsidy. If you're unsure about whether this situation applies to you, then please seek legal advice. The warranty of habitability is also a defense in a collections action. If there is a collections action filed based upon the non-payment of rent, the warranty of habitability would be a defense in that collection action, just as it would be a defense in an eviction action. So what are possible trial outcomes if you're a tenant and you've asserted the warranty of habitability as an affirmative defense in an eviction case, or as a potential counterclaim as well? The court is required to determine the reduction of a premises rental value in its uninhabitable state to the date of the trial. So what that word salad really boils down to is the court has to make a determination on this is how much less your residence is worth since you've been living with these uninhabitable conditions. And the length of time for those uninhabitable conditions is going to impact that reduction in value. So again, having that documentation showing dates upon which the notice was sent, the notice was received, those are all going to be critical when we're also trying to determine the amount of damages in a case. A court shall deny possession to the landlord and deem the tenant to be the prevailing party in an eviction case where the warranty of habitability is the defense to the non-payment of rent. Deeming the tenant the prevailing party is significant because if the lease agreement has a provision for attorney fees that are to go to the prevailing party, then the tenant may also be able to obtain an award of attorney fees in a case if they are represented by counsel. However, the court is, when they make that determination about what the reduction of the rental value is, the tenant has to then, even though they've won the case, they have to pay the rent that has accrued to the date of trial. And they have to take that also takes into consideration that reduction in value. But as a tenant, you do have to pay that rent. So if you withhold the rent, that's why it's so important not to spend it and to keep it set aside, because it's not a free month of rent, but the warranty of habitability has been breached. And this is a remedy for you to enforce the warranty of habitability as a tenant. This payment must be made either to either the court or the landlord within 14 days of that court's judgment that the tenant is the prevailing party. If, as a tenant, you don't do this in that 14-day period, then you get evicted. So the reduced rent, the court then awards possession to the landlord if the tenant fails to pay that reduced rent ordered by the court in the 14-day period. The court may also order the landlord to make repairs to the residence and correct the uninhabitable conditions, and also may order that the monthly rent that it be limited to the reasonable rental value until the repairs are completed. So landlords, if you've got a situation where it's going to take you months and a court to get something fixed, and a court has ruled this is the reduction in value, well, the court's going to be maintaining that jurisdiction to ensure that those repairs are completed. And you would not be able to charge the full market rent you had been until that uninhabitable condition is cured. Some other resources here would be the Department of Health, the Community Neighborhood Services Office for the city. If you're out in the county, you can also use the El Paso County Planning and Community Development Office out there. Again, just to reiterate, code enforcement only has the authority to enforce the minimum housing standards of the city code. It does not have the ability to enforce the warranty of habitability. Right? And we've been covering a lot of materials here to kind of highlight the differences between the two. The warranty of habitability can also be used for a defense in non-monetary situations. So it used to be the case that a tenant would not be able to allege that a notice to quit was provided was served on them because in retaliation. But it is a defense that if, as a tenant, if you make a good faith complaint to your landlord or a government agency regarding the warranty of habitability, then it would be a defense against a non-monetary eviction. So if there's an alleged rule violation that didn't really occur or a notice to quit, there are circumstances where the warranty of habitability would be a defense to other issues beyond the non-payment of rent. So at this point, I will open it up for questions if we have any. And then were there any areas that folks wanted me to kind of, I got through that a little bit quicker than I anticipated. I just wanted to make sure that we had, normally this is an area where we have the most volume of questions. So I wanted to make sure that we had plenty of time to address any questions that folks had. Mm-hmm.
So, a lot of the detail that you're talking about in the law, what happens if you try to do this and how the courts will deal with it, is, you know, once someone is actually has a case before the court. And so I guess my question really is, for people who are having these conflicts, if they don't have access, don't have good access to a lawyer, like, maybe that's not the way to phrase it. The question is kind of like, what else can people do if they, you know, before, or if they're having trouble getting a lawyer, or maybe they don't need a lawyer, maybe they need to do something else first. I guess my question is, what are those kinds of steps that people can be taking before they say, I need a lawyer right now?
So I think the first step is preparation. So if you find yourself in this situation, keep everything documented and keep it in writing. And I know I'm repeating myself a bit, but really the first step is getting that notice to your landlord. There may not be attorneys that would agree to represent you in filing a case, but you want to make sure that you have everything in writing and you know the dates back and forth because the timelines are going to matter. As far as potential resources, certainly I would recommend contacting any kind of Ask a Lawyer clinic, such as the one that the Justice Center puts on. Colorado Legal Services, you can apply online, in person, or over the phone at extension 444. And we also are at the El Paso County Combined Courts in the South Tower in room 163 on Tuesdays and Thursdays in the morning from 8 to noon. So you can come in and apply for services at that time if you'd like. Additionally, sometimes contacting neighborhood services to lodge a code complaint as well. Because that may be where you find out, hey, this isn't something that's covered by code, so I may need legal assistance in this case. Also, there are resources as far as the renter rights pack. There is a packet of further information that can be found online at the city's website. If all else fails, you can certainly give me a call at extension 169 at Colorado Legal Services. I very well may tell you, hey, you're going to have to apply, but at the very least, it can connect you with a live person, and we can talk about the next steps in you applying for services. One thing that I really want to hammer home here, among the other issues that we've covered, is that, and this goes to the withholding rent. The uninhabitable condition has to occur before the withholding of rent. So it's just because if life has thrown you a curveball and you're 2 months behind on rent, and then in month 3, your heater goes out, you may have a defense against month 3 moving forward, but months 1 and 2, that's not going to be subject to the warranty of habitability because that uninhabitable condition did not exist at the time that the non-payment began. Mm-hmm.
So outside of code enforcement, is there another way of enforcing these laws other than just going to court? Like, is that generally like where people, that's how it's enforced?
Yeah.
If you can't get someone to do the right thing right away.
the question is, where do you enforce, and Barb, if I'm misestimating here, let me know, but where do you enforce the warranty of habitability if your landlord does not willingly agree to it? And the answer is court. The warranty of habitability provides a claim, a counterclaim, and an affirmative defense to tenants. So that means you can file a lawsuit against your landlord. That's what a claim means. If your landlord files a lawsuit against you, it means that you'd have a counterclaim saying, well, their claims may be against me for this reason, but I have a claim against my landlord for the breach of the warranty of habitability. It also is an affirmative defense where you're stating, no, legally, I should not be evicted because because my landlord breached the warranty of habitability and I am not in unlawful detention. So that would be kind of a lot of legalese on the eviction side of things, but the warranty of habitability ultimately is enforced in court. If we're getting very creative, obviously parties are able to come to agreements on their own. So if you were to utilize maybe a mediation service, that may be something where it's a step less than court, but you are able to reach a resolution regarding any potential breach of the warranty of habitability. Well, if there aren't any more questions, I won't take up any more time from folks. Thank you so much for attending this evening. And again, I'm Clinton Albert. I'm a housing attorney with Colorado Legal Services. My contact information is still up on the screen. So if you have any more individual questions, please feel free to reach out to me after the presentation or tomorrow, and we'll see if we can link up and discuss your matter. Thank you.
Right, and I'm just gonna basically wrap us up by thanking everyone again for being here. And also just to remind you that we can send out the slides electronically if we know where to contact you. So you can sign up to receive those either on the Justice Center's website, that is justicecentercos.org, and navigate to renter rights, or on the Colorado Springs Community Development Division's website, that is coloradosprings.gov/community development. And you can click the link that says sign up for updates and join our email newsletter list. And we hope to see you at our next rental rights workshop, which is August 9th, focused on Know Your Lease. And the location is TBD. So again, sign up for updates so that you'll get that information. Unless there's any other last minute questions that came through, we'll sign off. Thanks, everyone. Have a great evening.